This session, the featured paper is that of Will Bode. The commentator will be Marty Reddish. We know what the rules are, so Will, take it away.
Practice lunging. All right. So it's black letter law that the federal government has a power of eminent domain. That is, if they need land for a public project, they can take it, so long as they pay just compensation. The Supreme Court established this power in 1875 in a decision called Cole versus United States. It's now pretty much accepted as conventional wisdom. In fact, it's hard for most people to imagine a world in which that would have been different. But it was different. So it turns out that for the first 75 years before Cole, Congress was not thought to have and didn't use a power of eminent domain. It's not that they didn't need land. They did. They built roads and lighthouses and railroads and military bases. But when they did, and when they couldn't get the land on the open market, they instead relied on the states to do the taking and to give or sell or transfer it to the federal government. And throughout this period, in fact, people repeatedly discussed and denied the possibility that Congress had a power of eminent domain. So in the paper, I do two things. One, the bulk of the paper is to just try to unpack how people could have possibly had this puzzling view, how it can be squared with the necessary and proper clause, how it can be squared with the takings clause. And then I try to figure out, what, as a methodological and doctrinal matter, we might make from this now. So on the first point, eminent domain is principally a question of enumerated powers. The Constitution contains the list of powers granted to the federal government. Eminent domain is not on that list. So if there is a federal eminent domain power, it has to be granted by implication. There's a clause of the Constitution that deals with implied powers, the necessary and proper clause. And you can see a kind of straightforward seeming necessary and proper argument for eminent domain. You say, well, Congress has the power to build roads or lighthouses or whatever it is. So naturally, if they need the land and can't get it some other way, they have the power to take it through eminent domain. And what's surprising is that the necessary and proper clause wasn't understood quite that automatically during the pre-Cole period. Instead, there was this limiting principle, this idea of what I call great powers, that some things were sufficiently important, sufficiently great, that they were outside of the domain of the necessary and proper clause. So one example I use in the paper is the power to tax. The Constitution contains a taxing power, but what if it didn't? You could imagine a sort of straightforward seeming necessary and proper clause argument for the power to tax. You'd say, well, we have these officers to enforce the law. They aren't going to work for free, or at least we'll get better ones if they don't work for free. So naturally, it's necessary and proper to have lots of federal taxes to pay for the operations of the government. But they didn't do that. They enumerated it because if they had left the tax power to implication, people would have thought that was a sufficiently great power or a sufficiently big deal that it couldn't just be sort of carried through without expressly saying so. Same idea comes up in the early debates with the constitutionality of the National Bank. James Madison is the one who gets up in Congress to argue that the bank is unconstitutional because, he says, the bank is chartered as a corporation, and chartering a corporation is a, quote, great and important power that can't be implied through the necessary and proper clause. That is, it's a power that the government has to have expressly granted or not at all. And even the people who disagree with Madison about the constitutionality of the bank actually concede the validity of the principle. So in McCulloch versus Maryland, when Chief Justice John Marshall upholds the constitutionality of the bank, he says, to be sure, there are a class of what Marshall calls great substantive and independent powers, like the power to tax, he says, that can't be implied through the necessary and proper clause, that have to be expressly enumerated if they're granted at all. It's just that chartering a corporation, he argues, isn't one of them. So that's the basic intellectual framework. It bears some relationship to what Gary Lawson and others have written about as the doctrine of incidental powers under the necessary and proper clause, although it may have some minor differences. But that's the idea about how something can be outside the zone of the necessary and proper clause, even if it seems to serve this means-ends relationship. Then there's the question of, is eminent domain something that is outside the necessary and proper clause? I think there's some ex-ante reason to believe so, in light of how it was treated in England, some of the statements at the time of ratification, but what really carries the weight is the post-ratification practice, and that is startlingly uniform. So from the get-go, when Congress does roads, lighthouses, everything else, it does it through the states all the time. In the 1820s, people first start to suggest, hey, wait a minute, maybe Congress has a power of eminent domain after all, and Henry Clay, in a fight over internal improvements, tries to get people on board with the federal power of eminent domain, but he loses. Even people, I mean, he wins the improvements project, but even the people who sign on don't sign on to a federal eminent domain power. Then in the 1840s, the Supreme Court confronts it in a couple of cases, including one called Pollard's Lessee versus Hagan, and there they say there's no federal power of eminent domain, and that keeps going in the 1860s. In fact, it's true in the Civil War Congress, even after the Southerners have left, during fights about the Transcontinental Railroad. Morrill of Vermont, Thaddeus Stevens both say, no, railroads should only take land in the territories, in the states, that has to be done by the states. And it's not until a few congressionally authorized takings later on during the Civil War, and then the Supreme Court's decision in Cole, that this pattern really changes. The one exception is the district and the territories, where Congress has plenary power, so sort of the great powers, enumerated powers project doesn't even come in at all. There are some early takings in the District of Columbia, but those are sort of always seen as different because there's no enumerated powers problem. Then, what about the takings clause? It says that private property shall not be taken for public use without just compensation. We know from Barron versus Baltimore, the Barron dissenters notwithstanding, that it's not supposed to apply to the states. So then you wonder, what's it doing if there's no federal power of eminent domain? And there are a couple of answers to that. One is the takings clause is phrased as a restriction on whatever power of eminent domain there is, not as a grant. So even if you sort of think it presupposes a power of eminent domain, it doesn't expand whatever would be there otherwise. And it could just as well be that it's therefore there to deal with the eminent domain power in the district and the territories, which seems small to us now, but there's a lot of land in the territories. There's explicit worry about the district in crafting the Bill of Rights. And in light of what we know about the origins of the Takings Clause, it might actually make even more sense. There weren't a lot of state-level predecessors to the Takings Clause, but there was one in the Northwest Ordinance. The structure of the Fifth Amendment actually mirrors the structure of the same provision in the Northwest Ordinance, so it may well be that the territorial protections in the Northwest Ordinance were carried over and produced the Takings Clause. Sort of the historical stuff aside, there's a bigger reason not to rely on the Takings Clause to produce a power of eminent domain, which is the Ninth Amendment. So recall, the chief objection to a Bill of Rights, the chief worry about having a Bill of Rights, is that it's dangerous. That if you say Congress doesn't have the power to do X, or it doesn't have the power to do X when certain circumstances are true, people will assume that Congress otherwise does have the power to do it, and the sort of what seems like a right will end up turning into an expansion of federal power. And the Ninth Amendment is what James Madison proposes and says is supposed to solve this problem by warning people not to infer from the enumeration of a right that the powers of the federal government are expanded in some way that would otherwise allow them to abridge that right. And so when we make the tempting seeming inference from the presence of the Fifth Amendment that there's a takings power, we're actually doing exactly what the Ninth Amendment was intended to forbid us from doing. That's the basic interpretive story, although there are a lot of details we have to get questions about. Then there's the question about, so what? You can use this, I think, to make a sort of straightforward originalist argument against Cole versus the United States and the subsequent cases about the federal eminent domain power. That'll depend on your theory of stare decisis and on whether a decision that's 138 years old now has somehow become too old to overrule. There's also sort of other doctrinal areas that I argue it casts some light on. That the same theory of great powers and the same kind of historical examples, I think, are a better account for what's going on in Alden and Prince dealing with sovereign immunity and commandeering. I think it's the same idea that the Chief Justice is trying to use in NFIB versus Sebelius when he's figuring out whether the mandate is or is not inside the necessary and proper clause. There are probably some other things like that it explains too. And that will depend a little bit on your methodology, but under the kind of original history plus subsequent practice methodology I use in the paper, some of those will rise and fall depending on what happened there. And that's the presentation.